try and move quicker. Just by way of introduction, I think it's important that the Council of Medical Schemes is noted as the statutory regulator of medical schemes administrators, managed care organizations, and medical scheme brokers, and that we perform this regulatory mandate in line with the Medical Schemes Act of number 131 of 1998. So our submission is done by myself and the team in representing the statutory regulator. Just a few comments in terms of how this investigation came about. Between the 6th and 15th of May in 2019 this year, myself, the chairperson of council, Dr. Mini, and the Minister of Health, Honorable Minister Dr. Aaron Motsoaledi at the time, convened several engagements, and at the heart of these was a request by the National Healthcare Professional Association together with other service providers. And part of the engagement was including these allegations and complaints of racial profiling, bullying, blacklisting, which were being leveled against the medical schemes and administrators. I think point 4 of that part, which is articulated in page 3, goes into detail in terms of the allegation, and I don't want to repeat these here. But I think it is important that these allegations have been dealt with by CMS on its day-to-day regulatory efforts, and it became more important for us to institute this investigation because of the fact that these were now in the public domain and they were including a racial element to it. So it became important as the regulator to ensure that there's an investigation put in place here to address these allegations. So basically, the industry that we regulate contributes about 4.5% to the overall GDP in the country, which is part of the expenditure on health. And basically, as I said, we regulate schemes, administrators, brokers, and managed care organizations. And this we do in the protection of the interest of 8.8 million members and beneficiaries. Currently, we've got 78 schemes, 26 administrators, 15 managed care organizations, and more than 10,000 brokers. And we regulate these in support of our members. Just a brief about the industry itself. In 2018 alone, the claims that were paid out by the medical schemes industry were at the level of about 172 billion rands. And when you look at all schemes combined, they've got reserves that are sitting at 62 billion rands. Just a bit of background around CMS and its function. CMS is a public institution established under Chapter 3 of the Schemes Act 131 of 1998, and its key functions are stipulated in Section 7 of the Act, namely to protect the interest of beneficiaries at all time, to control and coordinate the functioning of the medical schemes in a manner that is complementary to national health policy, to make recommendations to the Minister on criteria for measurement of quality and outcomes of relevant health services provided for by schemes and other services as the Council may from time to time determine. Investigate complaints, settle disputes in relation to affairs of medical schemes provided for in this Act, collect and disseminate information about private health care, make rules not inconsistent with the provision of this Act for the purpose of performance of its function and the exercise of its powers, advise the Minister on any matter regarding the medical schemes, and perform any other functions that would be conferred to the Council by the Minister. So this is really what sits in Section 7 and constitutes the mandate of the Council. Chairperson, I just want to talk to some high-level comments in terms of Section 59, Regulation 5 and 6, and these are captured in our document as pages 5, 6, and 7. And then I'll hand over to my colleagues here. So basically, when you look at Section 59, its main purpose is to guide charges by suppliers of service. And that first part, the first section there, it talks about the supplier of a service that has been provided to a beneficiary rendering an account directly to members. Here, this is where part of the problem sits, because it doesn't make any reference to the service provider. And I think part of this triangular relationship between supplier, member, and service provider is what is being articulated here. And you'll hear my colleagues talk about the case law, which basically indicates that whilst there's a contract or agreement between the supplier and the member, as well as the member and the service provider, this does not automatically apply to the suppliers of the service and the scheme. So in a sense, we believe part of the problem sits there. The second clause there talks to the 30-day rule and basically says that once an account has been rendered and it's correct, there are no issues, it needs to be paid within 30 days of being received. I think the interpretation there across the board is one could say almost uniform, but it is the third clause there that is often a point in dispute here. And this relates to the fact that this section actually allows that if the scheme have paid you in good faith as a service provider, and after some time make a decision that you're not entitled to the amount, or that this amount is a loss to the scheme due to theft, fraud, and negligence, it is empowered to deduct such an amount, from the service provider. Now, the issues that come from this here is that, firstly, it's not prescriptive in terms of how far back a scheme may go or an administrator may go to offset this loss. And secondly, it's not clear how a scheme would actually arrive at this point that, the money that they have paid is basically the service provider is not entitled to, or that there's fraud or negligence, related to this. And these, I think, are some of the issues that have led to the investigation itself here. And we hope that out of this, we will be able to get a clear way in terms of how this should be dealt with. The next part that I want to talk to is Dr. Regulation 5.
Dr. Kabane, before you move on, may I just flag a question for both you and your team, not necessarily to address now, but because you have been touching on the legislation and the regulations, it obviously is going to be discussed throughout these hearings, but I'm interested to know if you have any specific views on the meaning of the words in both Section 59.3 and and Regulation 6. So you will know that 59.3 allows the schemes effectively to, the wording, I'll read it for convenience, is to claw back amounts which have been paid bona fide in accordance with the Act to which a member or supplier of healthcare service, and the wording is not entitled. So I'm interested in your views on what that might mean. And then the second question is looking at Regulation 6 and trying to understand whether it's intended to implement Section 59.3 or not. Regulation 6 uses slightly different words and places constraints on how schemes should pay accounts and note what they call erroneous or unacceptable payment. So again, slightly different wording. And we're just interested, or I'm certainly interested in understanding if the CMS has any views on that, and if that any clarity comes out of your rulings. Thank you.
Can I just ask whether you want the answer now or right at the end after we've made...
Completely up to you, whatever's convenient.
Yeah, okay, I'll suggest that we make the presentations, and if it has not come out clearly, we can then zoom in and come and answer that.
Thank you, Dr. Kabane.
All right, thank you. And then if you look at Regulation 5, this addresses itself to the accounts by suppliers of service. And without going into the detail of what sits in there, in my mind, I think this is all the information that needs to be addressed when an account is being rendered for it to be considered by a scheme for payment. And basically, if you look at Regulation 6 here, it talks about the manner of payment of benefits. And this is where we also have a lot of, interpretations within the industry. Because if you look at that first clause there, which talks about how a scheme, can basically is not entitled to limit, exclude, etc., etc. If you look at that last part of that sentence, it actually addresses itself mainly to the timing of when this can be done. And there's an interpretation that it also then, also means that schemes are entitled to, limit, exclude, retain, in relation to scheme payments here. If you look at the second section of that regulation here, it basically talks about the erroneous and unacceptable, claims that are erroneous and unacceptable. And it seeks to explain how these need to be handled between the scheme, the service provider, and the member. And one is not certain whether schemes actually do inform members and service providers that there's a problem with a certain claim, and whether they do this within 30 days. And because if they don't do that, then basically it means they're in violation of that section of the Act. There's also the third clause here, which talks about an opportunity being given to service providers and members to correct problematic claims that have been put forward, whether these are erroneous or unacceptable. And basically, talks about giving them an opportunity to correct this and allowing them to resubmit so that this gets paid. The big question is, do schemes adhere to this and the administrators? And basically what also happens when a service provider either is not informed or is not cooperating with this here? We're hoping that, we'll get clarity in terms of what is recommended on the way forward here. Chairperson, on page 8.
Sorry, Dr. Kabane. Will your team be addressing the experience of the CMS in enforcing and monitoring compliance with Regulation 6 and whether schemes do comply or not?
Yes, they will give input in that respect. Yeah, the last part that I wanted to talk to, Chairperson, sits in page 8, number 5 there. We also believe that, Board of Trustees can be excluded from this allegations that we're currently dealing with, because we believe that in terms of good governance and the Schemes Act and its regulations, they've got a certain responsibility. And I think this investigation would need to also look at, the Board of Trustees. Now, in terms of our understanding is that the medical schemes are not expected to negligently fund claims even when there's a reasonable suspicion of irregularity. We also believe that the Board of Trustees of a medical schemes, in terms of Section 57 4C, need to ensure that there's proper control systems that are employed by and on behalf of the medical schemes. Again, we also believe that schemes and administrators through their Board of Trustees, in terms of Section 57 6A, need to take all reasonable steps to ensure that the interests of beneficiaries in terms of the rules of the medical schemes and the provisions of the Act are protected at all times. And basically, we expect the boards of trustees to ensure that, you know, the entities that they govern comply with all the sections, comply with the provisions of Section 57. We also believe that this is the part that enables schemes to be able to reverse claims, because the argument there is that they are protecting member interest. Chairperson, I will then hand over to my colleague, Mr. Paresh Prema, to take us through the benefit and rules.
Thank you, Mr. Prema.
Thank you, Chairperson. My section deals with the rules that medical schemes need to register in order to operate. I'm responsible for advising and recommending those changes to the registrar and the operation of Section 31 of the Medical Schemes Act. So in terms of the Medical Schemes Act, Section 31 deals with amendments of rules, the requirements of those amendments and the submission of those to the office, and the criteria in which the registrar would have to apply in order to register or not register a medical scheme rule. The main provision relied on by the registrar is that to ensure that the rules must, or an amendment to the rules must not be unfair to members or inconsistent with the Medical Schemes Act in registering those rules. There are further provisions in Section 31 which I'll deal with briefly during my submission. In terms of the Medical Schemes Act, medical schemes require rules to be registered in order for them to be governed in terms of those rules. And Section 29 of the Medical Schemes Act sets out the provisions that need to be contained in those rules. A particular section that deals with benefits itself is Section 29Q, which speaks to the manner in the payment of benefits according to a scale or tariff, recommended guide, and specific directives prescribed in the rules of the scheme. In far as the office is concerned in giving guidance to schemes as to the contents of the rules based on Section 29, there is a guidance document called the Model Rules, which we publish for schemes so that the interpretation of the sections can be put in their rules that are acceptable for the registrar. However, the Model Rules are a guide, and if schemes submit rule amendments that are different and are not unlawful, they are also registered by the registrar as long as they speak to the functioning of the scheme in terms of Section 29. We have to have that in case of different elements and different schemes having different, for example, restricted schemes may have rules relating to the eligibility of membership of a scheme. So model rules go more in terms of the normal day-to-day operations of a scheme and general governance of the scheme, how AGMs, when they are set up, quorums and things like that, which give guidance to schemes. In terms of Section 31, it states that schemes can only operate rules if they are approved by the registrar. So if they do not submit an amendment and operate a rule that is not approved by the registrar, those rules are invalid. And once they are registered, they are binding to the medical scheme in terms of Section 32. There are, as far as this investigation goes, there are certain elements in some rules, in some schemes that deal with Section 59 or the payment of claims, which are different to or add additional requirements by the scheme in paying those claims. And in instances, it's more to deal with the relationship between the scheme and the provider. As the registrar mentioned earlier, the Section 59 provision only deals with a member supplying the statement to the scheme requiring payment and not the provider doing that. So in instances where schemes have further rules dealing with the payment of claims around Section 59, it deals with how the provider does that. And I'll give an example of where we have a concern with one format of the rule that we have currently in one of the schemes and how we're dealing with that going forward. So there are a few small restricted schemes and a large open scheme that deal with these claims and the treatment of these claims submitted by providers. The rules that deal with these speak to the scheme investigating or finding concerns with the claims that deal with putting the scheme at risk, and that's the term that is used by schemes in the rules. So if the scheme finds provider putting the scheme at risk, then the rules deal with the remedies in that regard. It goes on, the rules go on to...
May I interrupt you just to pause, because what you're saying is significant, certainly, and I would like to understand it better. So are you saying some of the scheme rules actually set out rules which govern the service providers in the scheme, so don't govern the relationship between the scheme and the members? And my first question in relation to that is do you consider that then to be binding on the service providers?
No, it's not a rule that binds the service provider, but it's a rule which governs how the scheme will treat payments to those providers. So if the scheme, if a reading of the rule says, if the scheme investigates the provider and in the next section and based on justifiable reason has caused that the provider has put the scheme at risk, will then determine the way in which the scheme reimburses that provider.
Yes, I think I am understanding you. I suppose just what I'm trying to understand further is the provider's not necessarily in legal relationship with the scheme. So I'm interested to understand how the provider is bound by the rules of the scheme, and if there's any thinking around that. If this is determining how Section 59 investigations are managed by schemes.
Yeah. So as far as we are aware in terms of the rules, it guides how the scheme would review and decide on the payment to those providers, but it doesn't bind the provider in terms of any arrangement or any form of negotiation with the provider. But our concern with the provision is what is the result of the scheme doing that investigation. And the issue is not that it's a widespread, there is a handful of up to 6 schemes that do that, which there is a process in which we embarked on to deal with those. But yeah.
And just to reflect back what you're saying, so you're saying it's a form of internal governance that's displayed in the rules?
Yes.
Okay, thank you.
Sorry, Mr. Prem, I'm going to interrupt you as well. Are there any rulings or any precedents that flesh out what is meant by the phrase putting the scheme at risk?
Yes, so that is what has raised the concern from our side, and as such, we've taken certain steps to deal with the specific rule. My colleague from the complaints unit will also deal with the implications and the concerns that we have with the rule and the application of the rule itself. So so further on in my submission, we will deal with now the problems relating to this rule. But essentially, it's that to say that if the rule states that the provider is found to put the scheme at risk and the scheme has justifiable reason or probable cause, then the further concern we have is the rule states that the scheme will stop paying the provider. And that is a concern for us. And it wasn't an issue because this rule was registered in 2010. And when we found the practice in the way in which the schemes apply the rule, we then requested the scheme to change the rule. So Section 31(4) of the Medical Schemes Act is a provision that allows the registrar to write to the scheme to instruct it to change the rule in the manner indicated by him. The problem is, though, that is then a decision that can be appealed by a medical scheme if they're in disagreement with their director.
Sorry, which medical scheme is this?
I think they asked not to make schemes.
Apologies. Okay.
Carry on, Mr. Prem.
Sorry, maybe this isn't. Why can't you mention the scheme? Is it not a matter of public record, the rules and rulings in relation to? I didn't know that.
I
Okay,
think
we'll
carry
deal
on.
with it
We will
later.
come back to
that
you
question.
later.
Maybe late as part of
we
the final.
understood you made a request not to mention the schemes.
Yes.
So carry on. We will discuss it with you later.
But I think the point I want to make is it's not a widespread rule. It's a handful of schemes. So it's not, if you're looking at a practice across the industry, it's not based on this rule specifically, but it's part of the investigation. It's a good opportunity for us to raise our process, our concerns, and how we attempt to try to deal with these matters that come on. And these are matters that we deal with on a day-to-day basis as the regulator, because we deal with rules and changes to rules, amendment to rules, and when we find rules that are applied in an inconsistent way or inconsistent with certain provisions of the Act, what is the remedies that we have to deal with those? So as far as this investigation is concerned, that's the only provision that we find that we have a concern with relating to specifically payment of providers. What is important with this rule is it says gives a discretion to the scheme to identify providers that may have put the scheme at risk, but it doesn't go further to qualify how is that determined, and it mentions probable cause or justifiable reason, and then on that basis stop payment. That is our concern with the rule, and it's been picked up in all other processes in the office where the scheme uses that to not pay or find, that the investigation has revealed certain risks that the provider poses to the scheme, and as such, payment being stopped. Further on my submission, I talk about when it was registered. At that point, the rule was approved in order for the scheme to manage the risk, but the intention was for the scheme to do it on a case-by-case basis, not a blanket process. It's meant to deal with providers, and those are very few and far between that may pose that risk to the scheme. But we have identified these in 2015 that they need to be changed. We've written to them. The scheme has appealed that decision, and based on our process going forward, we may need to approach the matter at the courts in trying to get the schemes to reverse that.
Just tell me, the relationship between the service providers and the schemes, that's regulated by a contract. We call them the DSPs. Do you have any role to play in setting the terms of that contract?
No. In terms of the Medical Schemes Act, the schemes, if they choose to appoint a DSP, may appoint a DSP, but not contract. The word contract is not in the Act. It says you may nominate or appoint a DSP. We've had recent court judgments where it said that that would imply that there is an agreement, and we would want to see an agreement between the scheme which nominates a DSP. But in the absence, or if the scheme does not want to enter into a DSP agreement, a supplier may submit a claim and the scheme is required to pay, especially if it relates to prescribed minimum benefits.
I'm talking in instances where there is an agreement. What is your regulatory function in looking at the terms of that contract?
We don't have any function in terms of that contract because there isn't it's not related to the rules specifically. Where those contracts come into play or arrangements is the level of benefits that are paid to a DSP versus a non-DSP. That's where the rules would apply in terms of those arrangements.
So your understanding of your role is you enforcing the act and the rules, and you have nothing to do with the contract.
We don't have any role in the contracting specifically with those.
Thank you.
Okay. So the approval, again, we based on our request to the schemes to amend the rule. The appeal has been lodged, and there was a process around that which we are busy engaging in, so it's not concluded. But we have, our concern is, even though the scheme has its right to appeal the decision, it's important for us in terms of what the fiduciary duties of trustees are in applying a rule in the manner in which it gives them discretion to determine whether a provider will be paid or not, and also whether that is in the best interest of members in the cases where it's applied in a way that is unfair to those providers. As far as the other medical schemes are concerned, we are in a process to require them to remove those rules and apply Section 59 strictly. There is also a provision in the rule which says, which I didn't mention earlier, which says that if the scheme has found a provider to do that, they will notify the provider, and in instances like that, put the provider up on a list of providers that they have stopped paying. We've not seen that list, and we're not aware of the scheme, this particular scheme, doing that. But it's a provision also that is concerning for us, and that's why we've asked the scheme to remove that provision.
Is that a list that's available to all medical schemes?
So in terms of the rules, they've put in the provision to say they will create a list and they will publish the list for schemes, but we've not seen that list, especially related to this particular scheme itself, or the other ones that that we found to have a similar provision. But we've not seen that list. We've not seen them publish any list of that sort for those schemes concerned.
Thank you. Are you finished?
Yes.
Thank you. I mean, one of you still needs to answer Ms. Williams' question about what is the linkage between Section 59 and Regulations 5 and 6, because the two concepts that are used in the two are different. But maybe that's not you. Okay, so who is next?
Sorry, Advocate Ngcukaitobi, can I just ask a further question? Just to clarify this information that you're giving us, it occurs to me that whether or not there are provisions in the scheme's rules about how they manage their Section 59 investigations and clawbacks is actually immaterial, because it could be in the scheme rule and then you have visibility of it. But if not, because it's an internal governance issue, it may not be, and then you don't have visibility of it. Would that be a fair comment?
Yes, we don't.
Who is next?
Thank you, Chair. Donnie Clover. I'm the General Manager in the Accreditation Unit of the Council for Medical Schemes. Our function, Chair, is to accredit medical scheme administrators, healthcare brokers, and also managed care organizations. The registrar referred to the distinction between registering medical schemes and the accreditation functions, which we derive from Section 58 of the Act as an authorizing clause, which in this particular instance, insofar as administrators are concerned, is read in conjunction with Chapter 6. In other words, Regulation 16 to 27 of the regulations published in terms of the Medical Schemes Act. Chair, I think it's relevant to mention that the accreditation function or administrators are accredited by the Council for Medical Schemes itself. There's no delegated function to either myself or the registrar or anybody else. It is a council function, and I think it's also relevant to note that Regulation 17, insofar as accreditation standards are concerned, that those were developed over time. And as we speak, we're busy with the fifth edition, fifth revised edition of the accreditation standards, which have been developed over time at this particular stage. Our founding regulation insofar as the application of standards is concerned emanates from Regulation 17 to F for Foxtrot, saying that such information as the Council may deem necessary to satisfy it that such person, as administrator, A, is fit and proper to provide admin services, it has the necessary resources, skills, capacity, and infrastructure to render the service, and thirdly, that it is financially sound. Chair, there are a number of accreditation standards that are applicable to administrators, and insofar as this investigation is concerned, I may just, for context, mention that on claims paying ability. Now, what is important here is that there are several standards that apply to in assessing the ability of administrators and self-administered schemes, because self-administered schemes perform the admin functions from within their own resources. So it's their own ability, skills, capacity, but also infrastructure that enable them to comply with the legislative requirements. And this obviously includes Section 59, insofar as healthcare providers, and it may touch on the question, Chair, that you raised earlier on the contract, because Section 59, insofar as this is concerned, the accreditation function is concerned, would apply to when a healthcare provider renders an account by virtue of Regulation 5 and 6. There are other instances where accounts are not rendered, where contracts may come into play. But insofar as claims payments are concerned, or claimant of payment of claims, there, Chair, we have 23 standards, for instance, to check the ability of an administrator or a self-administered scheme to do that. It's not a detailed audit, but we look at the ability of those entities to be able to pay that. Then there's a further standard to suggest that, you know, just to give you an idea, that if claims have to be reconciled and have to be paid in accordance with scheme rules, in respect of beneficiaries entitled to receive those benefits, and for instance, if there are discounts received from providers or negotiated, that those discounts go back to the schemes and not to the administrator or utilized for any other purpose. Then there's a further requirement also incorporated in terms of the standards, and that is to say they must have the ability to produce at least monthly reconciliations between the operating and financial management systems, including but not limited to contributions, claims, and savings accounts. And then another, I think for context, is also a standard that says the administrator has in place processes for the early detection and mitigation of irregularities and illegal acts by employees, members, and providers. So obviously, irregularities is not limited to, and we refer to irregular claims as well, because I believe there may be claims which are paid erroneously, which may be irregular, not necessarily in a fraudulent manner, but irregular by virtue of, what was previously discussed, not entitled to, and therefore invoking Section 59(3). So, Chair, again,
Mr. Kola, I mean, the terms fraud, waste, and abuse, how do we define them?
Chair, I'm not a lawyer. Can I?
I just want the functional understanding.
It could be. I believe the generic reference to fraud is a deliberate act.
Yeah.
It may be seen by me as a layman, as a layperson, to be a deliberate act to defraud a medical scheme or. But I think what is also important is, and the standards are framed along that basis, to say, well, it's not necessarily providers, because irregular claims or an irregular act, fraudulent, wasteful, or abusive payment of, may also relate to, for instance, a member. It may be member inspired, which quite often happens. Wasteful and abuse may be inconsistent, in my view, with the rules of the medical scheme. In, for instance, the event that there may not be a limitation on, for instance, a number of consultations or of medicine dispensed, and so on and so forth. It may be. And I think it's very relevant to also mention to yourselves that, many of these claims must be gender sensitive. In other words, the system must be able to identify claims with regard to gender or to children versus adults versus, the elderly people. Dental, you can't, it must be capable of identifying a claim instituted by whoever for one tooth having been extracted on a third occasion, that kind of thing. Chair, I think in conclusion, I think the registrar made reference to the role that the Board of Trustees and the scheme should play in identifying and appropriately managing claims payment and mainly reports. And I think there's lots of scope for improvement as it relates to that, because if we analyze the agreements between medical schemes and their administrators, they are, and we do focus on that as part of the accreditation function, to scrutinize the contracts for administration and to ensure that there are service level agreements in place, that there are appropriate penalties in place for not compliance, but I think also moreover to focus on the kind of reports and the frequency of reports as it relates to a variety of aspects covered during the process of administering the affairs of a medical scheme, to provide that necessary feedback to the Board of Trustees via the principal officer, and for appropriate attention and management to be given to that aspect. Thank you.
Mr. Culver, the way I understand your evidence is that as part of the accreditation process, you do scrutinize the administration contracts between the schemes and their administrators. I mean, to accredit an
That's correct.
administrator, you scrutinize those contracts.
Very much so.
And I also understand that it is the administrators that are often applying Section 59 on behalf of the schemes, but nevertheless doing the active work in relation to it. So do you see in these contracts provisions which determine how Section 59 will be applied?
Yes. Ma'am, the service level agreements would inter alia provide for, if we go through the standards, is to say, well, are eligible claims being paid within a period of 30 days as provided for in the Act? Furthermore, how they deal with unacceptable accounts in the event that accounts are rendered for payment, how they deal with that, but also a fundamental aspect thereof would be to notify members, because there is a regulation, I think it's in 5 or 6, where it says that the members must be advised of how a particular claim, claims payment advice, how a particular claim has been handled, date of service, date of receipt, date of payment, or if there is rejected or queried, then on what basis is it being queried, and then allowing for sufficient time. I think the registrar made reference to that, of resubmitting such an erroneous claim for payment within the prescripts. But on average, yes, provision is made in the service level agreements for the kind of reports that that need to be submitted to client schemes.
Just tell me, I mean, one of your standards is that an administrator should have an early detection method for claims that will either be fraudulent, abusive, and wasteful.
Yes.
Now, do you review these accreditation agreements on a regular basis? Because the reason I'm asking you this, maybe you can comment on this, is that we've listened yesterday to doctors complain that we submit an invoice, it's paid, and then 3 years later, we are told that there was something wrong with it. And yet, an administrator has come to the CMS, got through the system on the basis that they have an early detection system. But it turns out they don't. But they still got the accreditation.
Chair, I believe identifying unacceptable claims may likely take place on a retrospective basis, because I believe an administrator or a medical scheme may pay a claim bona fide when it receives it within a period of 30 days. And however, it may become clear when they do a retrospective review of claims payments that erroneously so.
No, I understand that,
Yeah.
but I mean, take the examples we were listening to yesterday. It's 3 years after the event, and I'm now told to go and find my clinical notes. Patients are gone, I don't even have any connection with them. But your own standards for accreditation is that it must be early detection.
Yes, yes.
So why are they getting through the early detection system if their systems are only retrospective?
Yeah, Chair, I think it's for that reason why I strongly, suggest that, that entire arrangement ought to be more carefully looked at and managed by a board of trustees, by a principal officer, to avoid a situation. And I'm sorry, I didn't listen to all of the testimony that was submitted to you yesterday. But to avoid that kind of thing, to focus more on the early detection.
No, I'm asking about CMS. You are accrediting people on the basis that they are required to have a system that will ensure early detection. And they come back to you and they ask for accreditation, you still give it to them.
Chair, yes. That may be, although from an accreditation perspective, I think it is important for us, for accreditation purposes, to say, do they have the ability to actually do that? And then obviously one would believe, or verily believe, that it is dealt with by an administrator, like, for instance, the ability, claims payments within the prescribed period of time, and how they deal with it as a modus operandi, or the manner in which they do it.
But why do you believe that when the evidence shows that they don't? You say that I verily believe that you do it, and then there are people saying, actually, that's not what happens.
Yeah, I believe that is perhaps an area which, between the accreditation process and the auditing process of, the statutory audit of medical schemes and of administrators, ought to be scrutinized in order to verify the detail, to investigate, to inspect the detail, as opposed to us checking for the ability and to see that systems are functional, that the processes are in place, without necessarily going into detailed audits. We're not shying away, Chair, from that responsibility. In fact, it may be an area that we, from our perspective, we can maybe increase or enhance by taking samples to verify that particular aspect.
Thank you.
It's related to the question my colleague has posed to you. What is the responsibility of the CMS in relation to administrators? What regulatory oversight are you entitled to perform?
I just want to make sure if I understand the question correctly, the responsibility of the CMS towards administrators.
In exercising its regulatory oversight over administrators.
Right. That fundamentally is derived from the accreditation standards and the accreditation process. For instance, if an administrator, upon application for accreditation, is found not to be compliant with any of these standards, then what we ordinarily do is to invoke or to propose to council that resolutive suspension takes place upon the applicant not being able to comply with a particular standard. I think also what is as part of our regulatory function is that we conduct on-site investigations or inspections at the facilities of administrators, mainly to test the ability to look at the processes, particularly since we're talking, Chair, about of different systems that need to interact. Because you would have a financial system, you would have a database, a member management system, and to integrate the two to ensure that they comply, and that's quite an intensive process carried out by staff in the accreditation unit during the on-site investigations, and that's to say, because the arrangement or the regulatory provision is seen that they must comply with the accreditation standards and with the relevant legislation throughout the period of accreditation. And we have the ability, for instance, if there are complaints lodged as it relates to treatment of whichever aspect by a particular administrator, to investigate same and to to look ad hoc at areas of concern.
I'm not sure if I missed it, but how often do you review the accreditation approval of the administrators?
Every 2 years.
Every 2 years.
Thank you. Oh, yes, Dr. Kaban.
Chairperson, I just wanted to add to the answers here, because I don't want the investigation panel to leave this discussion thinking that CMS is actually doing an excellent job in terms of, regulating through accreditation. We do have severe resource constraints. In my initial presentation, I mentioned that we've got 26 administrators, and as it has been said here, we accredit them for a 2-year period, and then they reapply. Now, what happens in between the accreditation is that because of resource constraints, we can't go to every entity that we have accredited and check whether they are compliant, with all the standards that we have been giving them. How we do this is more on a sample basis, or where there has been complaints to the CMS, and we have to go to the scheme either to do an inspection and to check whether, those systems are in place. So it may well happen that once you've accredited an entity, in between those accreditations, these systems are no longer in place, and it may also happen that, the schemes and these administrators do things that we are not aware of as a regulator, and only pick it up when we're doing the re-accreditation. So there is a gap there. And part of it, it's the human resources and the systems that we would need to actually do, almost on a continuous basis, a follow-up on all of these accreditation entities between those 2 points at which we do accreditation. I just wanted to expose that gap that we hope moving forwards we will also be addressing.
Thank you. I think he wants to also add.
Chair, can I just refer to the earlier question about going back 3 years
Yes.
to investigate unacceptable behavior and to then deal with it retrospectively? I believe that investigations of this nature are not necessarily carried out by administrators in toto, because I believe that schemes have the ability, and they perhaps do appoint investigative teams, forensic auditors, and so on to actually do that. That function per se is not specifically accredited as part of an ordinary administration agreement. But I think also what administrators may likely testify before you going forward is that they have the ability to, for instance, collate claims on a collective basis, because they administer a number of schemes, and medical schemes collect big data, and as part of that accreditation or the process of verifying claims, looking for unacceptable behavior in whatever way, shape or form, enable them to from a collective or a collation of data of all medical schemes under administration may point to certain unacceptable behavior collectively, which, Chair, the question you posed will by and large be retrospective in nature.
Thank you.
Sorry, Mr.
You carry on.
Mr. Gover, can I just take you back to this, the question I flagged earlier? Because I think it's quite important to understand the accreditation division's view on the interaction between Section 59.3 and Regulation 6. So we had a short exchange where it seemed to me that you were saying those accreditation agreements are approved on the basis that they implement Regulation 6 to the extent that, for example, schemes might be required to determine if a claim is erroneous, or I think the other word is unacceptable within 30 days. And then you suggested that certainly is in the KPIs, I think you said, or something along those lines. Or you check the agreements that this is the case. But you haven't explained to me, and then you said, and you see that as implementing actually 59.3A, not being entitled to the benefit. But you haven't explained if the provision which is about fraud, theft, misconduct is also governed by those that 30-day rule and the 60-day rule. Sorry, my question is now not entirely clear. But what is the accreditations division's view on the meaning, whether Regulation 6 fully implements Section 59.3? That's really what I'm getting at.
I think the short answer to that is that there is a statutory obligation to pay valid claims within a period of 30 days. And then, if that doesn't take place, is how in a different way are those claims that are not capable of being paid dealt with.
But should fraudulent claims be dealt with as claims which are irregular? That's what I'm trying to understand.
Fraudulent claims in our experience is, once identified, then obviously it must be dealt with in accordance with practices in place. And by and large, you may find different medical schemes having different policy.
So if that's the CMS's interpretation of the section, then that does outlaw retrospective audits, as I understand it, because it will place an obligation on the schemes to recognize irregular claims within 30 to 60 days. And I'm talking now about fraudulent claims.
Yes, no, I wouldn't be in a position to comment, on that, because I think, with jurisprudence having been developed over time, I think my colleague dealing with explaining, complaints and related to that, may be better positioned to express views on that.
I mean, your function is accreditation. I mean, we're trying to tease out whether regulation by accreditation could not be one of the options available. Yeah, all right. Thank you. You are finished with your presentation?
I'm finished with my presentation.
Thank you. Who is next? All right. Sorry, just remind us your name.
Tembegile Paswane.
Paswane.
Yes.
Ms. Paswane. All right. Yes, thanks, Ms. Paswane.
Mine is to take you through the role of complaints adjudication insofar as it relates to complaints by healthcare practitioners in the application of Section 59 by medical schemes. What we have just at the onset, Chair, is just to indicate to the panel that with regard to racial profiling, CMS does not keep statistics in terms of the complainants, whether their racial background or ethical background. We just process complaints as they come in. We don't classify them in terms of race. What we looked at the allegations that are brought before the registrar's office, and to indicate whether are those allegations matters that are provided for in the Medical Schemes Act. Some of the allegations that are brought to CMS indicates that medical schemes have arbitrarily suspended the payment of claims by healthcare practitioners, that they asked to pay certain amounts of money to the medical schemes, and they regard this as unlawful or unjustified. In the letters that they sent to CMS as attachments to the complaint, they indicate that medical schemes have written to medical practitioners to indicate that there are certain billing anomalies that were found, or the number of suspicious claims that were submitted to the medical schemes for payment, to which payment was already made to the healthcare practitioners. And it will go as far as indicating now that the medical scheme is conducting a retrospective review of all the claims for a particular period, and then they are required then to submit information to the medical scheme relating to those claims that are under scrutiny or that are being audited. Questions that will be posed or evidence that will be asked by medical schemes and administrator to the healthcare practitioners that provide with us consultation hours in respect of this number of patients or claims, the location of your practice, what are your operating hours, purchase of consumables, equipment, what's your qualification. If you've got locums, indicate the names and how many do you have them in your practice. What's the time that you spent consulting each patient? What are the hours that you are working per day? Where can you get clinical notes? Some medical practitioners will cooperate and submit information as requested by medical schemes. Some will refuse. Some will submit incomplete information to the medical scheme. And medical scheme will indicate that they won't be in a position to conclude the audit in the absence of all the information that they've requested from the medical practitioners. And then once they are resisting or uncooperative, that's then that they'll be given a further correspondence indicating that direct payment to those practitioners will be suspended pending finalization of the audit. So what we looked into as a unit, we looked at, is there any contravention of the Medical Schemes Act in the manner in which the medical schemes or administrators have conducted themselves in suspending payment and also withholding payment and not even paying claims moving forward. So before we even issue a ruling in those complaints, we refer those matters obvious to the medical scheme as prescribed by the legislation for comments. Once we get comments, we'll go through the information. If there's further information that is required, there'll be ongoing engagement between our offices and medical schemes and administrators relating to those particular matters. Once we issue a ruling, we'll take into consideration a number of issues that we raise as well as information that is before CMS. So in all our rulings, we always clarify the legality of medical schemes or administrators' conduct in withholding payment and offsetting the value of the alleged irregular claims against the ones which are owed to the medical scheme. And you'll find that in certain instances, the information that is sent to CMS and to the medical scheme, you'll find that it doesn't match the claims that were submitted at the time. Just to give you example of the number of issues that we've seen before us, you'll find certain medical practitioners, dentists in this instance, where they've inserted jewelry in the teeth of members but claimed for a benefit that is covered in the rules of a medical scheme. You'll find that payment was made in respect of those, but there's evidence and there's affidavits to show that services that were rendered are not those that are provided for in the Medical Schemes Act, but payment was made. Going to Tani, the issue of Regulation 6, whether it applies, medical scheme have got 30 days to pay the claim. Once they look at the claim as it stands, it looks as if the claim is valid, but those affidavits would show that services that were rendered were not those that should have been funded by medical scheme in those instances. In certain instances, non-members are treated, but the claim will be submitted as if a member of a medical scheme was received services from that medical practitioner. We know that if you're a non-member, there's no way that the claim can bear the details of a member. Clearly, it's a collusion between a member and a healthcare practitioner in those instances.
According to the CMS, why does a scheme need 30 days to pay a claim?
Why does it need 30 days?
Yes, the Act says it must be paid within 30 days. But I mean, don't they need the 30 days to verify the validity of the claim?
They have to do that and then pay within that particular period. If the claim hits the medical scheme, maybe day 5 after the date of receiving services, then they've got the 30 days from that particular date at which it was received to pay the claims. And we know once they make the claims, the number of human errors that happens, you find that they've paid the claim. But due to this retrospective then validation of claims, they found those erroneous claims because there's a shortened time frame within which they should pay. So there are those instances where they've paid a claim, but where that claim was not supposed to be paid.
I mean, what's your experience on this? Do the schemes actually properly verify the validity of the claims in 30 days, or do they just take it at face value?
Not in all instances, Chair.
So what do you mean?
Some claims, you find that they are proper, they are paid correctly, but some they are not paid correctly. You see, even other complaints not relating to Section 59, if there was a claim that was supposed to be paid, but there was an admin error at that time, but the claim will be paid.
No, I
Later
understand
on,
that.
they
No,
reverse.
I'm asking a different question. I mean, if the purpose of giving a scheme 30 days is to validate the claim and to make sure that it's the correct and accurate claim, what is your experience as CMS? Do you find that schemes, in fact, use that 30 days to validate the claim, or do they just pay the claim with very superficial validation and then investigate afterwards?
It's both, Chair. It's both. It's a combination of both. You'll find in the responses that we get in complaints, it's only then that it's an oops, oh, we've made an error. Now we are going to reprocess. So
they don't actually properly scrutinize the claim in that 30 days?
not in all instances, hence the evidence that is before us.
Yeah.
Ms. Puswane, is it permissible for a scheme to impose a restriction on the payment of a supplier pending an investigation?
I think it's permissible, Chair, because it's those risk mitigation measures that medical schemes are supposed to have.
But I need to understand that more. Why is that so? And if in that scenario, there's no finding by the scheme that there was an erroneous payment, an unacceptable payment, and fraudulent claim, or whatever the case might be. They're simply saying, we think there might be an issue, we want to investigate. In the meantime, we're not going to pay your claims. That's permissible.
It is permissible, Chair, because even though there may not be a finding at a particular time, it's those instances where audit is not yet concluded. There's evidence, but they need to make sure that they wrap up the entire investigation. Hence, I've made an example that we've had, even before us, we had affidavits showing that services were not rendered at the time. But the medical scheme is withholding payment because it's calling upon all the information that will enable them to conclude that exercise and reach finality, then make payment. So it's reasonable to suspend pending finalization. Once
And how long should that investigation last? Is there a limit to how long that investigation will be?
That's the gap in the legislation. There's no time frame whatsoever. But
So
please
if
note
they take
that
6 months to wrap up the investigation, and at the conclusion of the investigation, they find that there was no irregularity, what happens then?
then they need to release the funds that are due for payment to the service provider.
So the 6-month period in which they were not paying claims, they will now pay the claims.
They have to pay those claims.
And the
Which
burden
are
of the
valid.
interim period will then be on the supplier for having to, the burden then is on the supplier, is that right?
Yes.
I mean, this is the point, isn't it? So for 6 months, you are sitting there as a GP, you are not getting paid, and then you are told that you might be paid after 6 months. And the CMS thinks there's nothing wrong with that.
Remember, Chair, audit has to be concluded. And the legislation does not even provide a time frame. So CMS cannot say that 6 months is unreasonable, but we've made a pronouncement in the number of rulings, especially where audit took over a year, where we say that it's unfair to prolong this audit. Audit must reach finality at certain stage, because you cannot withhold payment or saying that you're investigating indefinitely. So a period of 1 year, that's why we made a pronouncement or ruling, say that this period is unreasonable. But where I'm sitting 6 months, and it also depends on the cooperation of a healthcare provider. If they don't provide that information, because in many instances, I'm busy, I don't have time, I'll get back to you, then it delays the actual conclusion of the investigation of the claims audit.
What is the authority that you are relying upon that entitles the scheme to terminate payment pending the outcome of the investigation?
There are a number of of judgment by our courts as well as the appeals board. I'll name two cases which were held at the appeals board, which those two cases are very important because they've overturned the decision that were made by the council, the appeals committee. There's one case relating to Paul Med versus Dr. Payne. The second one relates to James versus Council for Medical Schemes and Umpemensi Pharmacy. In those judgments, the appeals board made it clear that in the absence of contractual relationship with the scheme, the supplier has no right to insist on direct payment by a medical scheme. So in our rulings, we don't depart from those judgments as well because they are precedent setting. They overturn the ruling of appeals committee saying that the scheme is correct under these instances. Hence, we rely on them then in arriving at our decisions.
Sorry, that's very important. You're talking about restriction in the sense of direct payment. So you're saying that that would be permissible, but would it be permissible to completely suspend payment of claims?
Remember, when they suspend payment of claims, they pay members instead of you as a certain provider.
Is that a fact?
Yes.
Well, I mean, you know, yesterday we had evidence here that what schemes do is that they will not necessarily put you on direct payment. They will simply block the service provider completely, and they will tell the patients that you are not to use that service provider because he is blocked. So when we say, what authority do you rely upon that a scheme is entitled to suspend a service provider, we're not asking you the same thing as what authority exists for direct payments. So is there anything that allows the schemes to suspend a doctor or a medical practitioner, including informing their patients that they are blocked?
Well, the issue of blocking, I think it's an issue that was dealt with by our compliance unit. I think Mr. Cele will be addressing that because they've dealt with one big medical scheme where it blocked a healthcare practitioner. But in respect of the complaints that we've dealt with, those ones that I was making reference to, it's when they are just suspending payment at the time, but paying members. But doctors will insist on direct payment. Don't pay members because it's difficult for me to recover the monies. Pay me directly where they are compelling medical schemes to fund them.
Sorry, I just need to clarify this because that is the language that's used and in the evidence that's been provided to us, letters that are sent to medical schemes, is that they are told that payment will be suspended. And you're saying we are to interpret that payment will be suspended. Payment in respect of claims from your practice will be suspended, meaning that means members will be paid directly and not the practice.
Yes, that's why I cited those judgments, ma'am, because I was referring to those in particular. I can continue now. Lost my train of thought. But in certain instances, you find out in the rulings that were made by the office, we make it clear that where a medical schemes cannot verify the claims which are under audit, then there was no basis for medical schemes to release payment due to the failure of a healthcare provider to provide that information that will enable proper validation of claims. However, in certain instances, you'll find out that even though we're making a pronouncement on funding decisions, but there are issues that are raised in complaints that relates to the role that should be played by other statutory organizations or other societies of that complainant. Example, with clinical psychologists or psychologists in general, where a medical scheme will dispute the length of notes that are indicated during consultation, where they say that we won't fund you because you just submitted a one-liner in this particular consultation. Your records are not detailed enough, you know, the information is not clear. What we're saying as an office, we are not in a position to adjudicate on those issues. Medical schemes should go a step further and consult the society of psychologists, for example, to make a pronouncement on that matter. Then CMS will come at the tail end of that to make a determination whether funding should have been made or not. Because you can't say now, because the notes that were written on the date of consultation are just one-liners, therefore the amount that they've claimed doesn't correspond with that. We can't make such pronouncement. That's why I say that refer it to other organizations then. In certain instances, when it comes to the issue of codes, billing, we say that HPCSA must play a role. The matter must also be referred to HPCSA. HPCSA must look into these coding disputes, make a pronouncement, then it will come to CMS at the tail end of that dispute, because there's no way that you can say medical scheme release payment or the doctor, you are entitled to payment in the absence of information, because now we'll be encroaching on the role that should be played by other regulators or societies of these healthcare practitioners.
Sorry, Ms. Piswane, how do you deal with the complaints by suppliers who say that they are requested to provide confidential information in violation of their ethical codes? How do you deal with that, where members have already signed an agreement with the schemes that they may access confidential health records?
We've gone through the terms of the application form in detail to see what exactly has members consented into. You'll find that they are informing medicals, or they're giving the medical scheme the right to request confidential and private information. You can give it to, in this instance, to a medical scheme, to an administrator. However, the use of that information must be relevant to the issue in dispute, in this instance is payment of claims. But you find out the issue now relates to healthcare professions councils, where they say that you need to get the members' consent, meaning that there must be another consent where the member maybe submits in writing to indicate that I allow you as a medical scheme to share this information or to disclose. So there are just those, because I know that there was also a view which was shared by the registrar earlier, saying that medical practitioners are not supposed to disclose information without the written consent of patients. So those are the two areas. The contract that the members enter to gives the scheme and administrators a permission to request information and to use it for the purposes of administering the claims. But another organization, meaning that they need to have another written consent. So those are the two areas which we like dealing with as an office.
Sure, and I appreciate that there are lines between you as a regulator and the HPCSA and their ambit of regulation, but you have oversight of the rules, over the rules that members sign, right, with the scheme, and they sign as part of their membership of the scheme that they consent to the provision of that information. Do you have members who later then complain when they are asked to provide that information? Have you had those complaints from members of medical schemes?
No, we don't have that. We don't have them when they say that they've never consented, not before us.
No, I'm not saying the complaint that they've not consented, but I'm saying, have members complained about having to sign that type of consent as part of an application?
No, ma'am.
To be a member of the scheme?
No.
There have been none of those complaints?
Yes, none.
Sorry, may I also interrupt you there? Just to go back to your comments in relation to dealing with complaints about clawbacks when there's a coding issue. So where a provider might complain that money was, he or she was required to pay back money where he or she might have used the incorrect code. Please explain how you deal with those sorts of complaints.
What we've done in respect of those, we arrange with Health Professions Council that will be referring those to them so that they go through them, because they've got a mandate in respect of the codes to come back to us. But unfortunately, there were delays in respect of that area, even escalated to the registrar, saying that, can you please take it further with HPCSA, because we need to resolve a number of complaints which pertains to the coding disputes. What happens in those areas, we find that we don't get a response, hence the escalation that we've done as a unit, because we found that they were creating a lot of backlog for the unit because you couldn't resolve them, saying that we need a view from HPCSA, and doctors will tell us that, but we're never trained on coding. Hence, I use this code. They've been paying this code. It only came to my attention at this time that now I'm not supposed to code in this way, but on the other way. Hence, we say that HPCSA is the right forum to make a pronouncement on those matters.
So we heard evidence yesterday from the Competition Commission that there are numerous codes that are being used. So I am surprised that it goes to the HPCSA, because I wasn't aware that they were responsible for a code that was in use.
Yes, there are different codes, ma'am, that are used, and they come from different institutions. South African Medical Association also publishes a coding billing manual where medical practitioners refer to as to how they code. So there are just many codes in the industry by different societies, and other societies will come out with their codes as well. So the coding issue is just all over the show. We don't have a coding authority at this stage because there's currently a gap in the system. Hence the CMS under the registrars, where they made a proposal that we need to have a coding authority as a country due to these anomalies relating to codes. Every society comes up with codes and expect medical schemes to fund. Medical schemes say, no, we don't recognize that particular billing manual, but we rely on that manual. So that's why—
Sorry to interrupt, is it fair to say that it's impossible for you to resolve a coding dispute then?
In certain instances we do, because we rely on the NHRPL, which was the coding, I'll call it a guideline that was issued to the industry until it was repealed and it was outlawed when the matter went to court.
Thank you. Do you still have more to say? Or can wrap up?
Yeah, just to wrap up, there are some concerns that we've noted as a complaints unit relating to the Section 59.3 complaints. We noted that some decisions to commence deducting amounts which are allegedly owed to medical schemes are not preceded by transparent and credible investigation. You'll find that there's a letter that is sent, but you could see that there was just no evidence coming from that. Or two, in certain instances, there's no detailed report founded on factual evidence of the irregularities, and the quantification of those amounts are always not clear. Medical scheme will just give you that it's estimated that service provider X owes us this amount. When you ask them for quantification, that's where the problem lies. It appears that in certain instances, it's a thumbsuck. Lastly, we were also concerned where investigations were prolonged and appeared to run indefinitely, and then we advise in those rulings that such investigations should be expedited and brought to finality sooner due to the time that has lapsed from the time in which they started with the investigation until the doctor complained to CMS. That concludes my presentation.
Thank you. What's going to happen now this side? Mr. Letsualo and Mr. Qel, how are you going to deal with your presentations?
Thank you, Chair. Chair, I'll just take you through some of the litigation and appeals that we've had as the Office of the Counsel for medical schemes.
And you are in legal?
Legal, yes, that is correct, Chair. Chair, we've also made available some of these copies of all this judgment and rulings for ease of reference. I will not go much into detail, but just to highlight one of the standout cases which to a certain extent deals with the problem surrounding Section 59. And that was an SCA judgment, Sechava Medical Solutions versus Sikete. And this particular judgment, Chair, it provides circumstances to which how the relationship of a scheme and a service provider should be. We've chose this matter for one reason. Some of the matters that were decided in the appeals committee and the appeal board are subject to the SCA. So when we look at the authority in relation to how the relationship of the scheme and the service provider ought to be dealt with, we're mostly guided by the SCA judgment. Chair, in short, and I'll take you through the comparison of what the position is.
Let's have something. I mean, yesterday we had evidence that the CMS is not enforcing its own rulings and the schemes are treating CMS contemptuously. What is your comment on that?
Chair, I think that particular question will depend on the ruling which sits within body. It may be a ruling which sits within the registrar's office, which may be appealed by a scheme to the appeals committee, which will in effect suspend that particular provision. It will also depend whether that ruling, is it a ruling of the appeals committee being appealed to the appeal board. So, Chair, that particular evidence has to be factualized to the extent that where would that ruling be coming from? Will it be coming from the registrar's office? Because if it is appealed, then it is suspended. Unfortunately, there's an express provision under the Act which says the registrar or the office cannot do anything. So just to contextualize that particular predicament, it will depend upon where the ruling is sitting within the internal remedies or the internal forums within the Council for Medical Schemes.
So the perception yesterday, I mean, I just want to give you a chance to deal with it, that some medical practitioners perceive the CMS as toothless because it's giving rulings that are not being enforced. You say that may be sometimes a consequence of a legislative enactment, because even if you've given a ruling, it cannot be enforced until the appeal is finished.
That is correct, Chair. I think just to give context, if you look at the ruling that is made by the registrar, and you look at the particular provision that relates to an appeal of the registrar's ruling, the Act is clear to say that particular decision it's suspended pending the finalization. So it is regrettable that there would be that particular misconception that we may be toothless, but it is because of the express legislative terms of the particular Act.
Well, I mean, the other complaint is that you are not enforcing your own rulings.
Chair, I think that again becomes a problem, because if there is a blatant statement to say we're not enforcing our rulings, I'll have to stand by my earlier submission that I made to you, Chair, to say it depends where the ruling sits. If it sits within the registrar's office and it's appealed to the appeals committee, unfortunately, it is a legislative issue because there's an express suspension of the decision. However, when the matter sits within the appeals committee to the appeal board, we've had challenges, but our view has always been where there is a latitude to enforce, our compliance and investigation unit will issue those directives or those penalties. However, where there's an express, like in this particular case on the registrar's ruling, unfortunately, will particularly submit that there may be that conception that we are unable to act, but it is because of the challenges that we face in terms of the legislative terms that we have currently.
Yes. But what do you do with this? So you make a ruling that a member must be, a scheme must honor a particular account or a relationship with a service provider. They don't want to, and there is no appeal. What is the actual mechanism that you have to force the scheme to comply?
No, thank you, Chair. I think that is quite an important question. That that question sits with our enforcement and compliance team. I think my colleague, after my presentation to you, he would probably touch on it as to what are the steps. But one of the things is they will normally issue, they can start even imposing penalties under Section 66 of the Act because of non-compliance. But now the challenge becomes when the scheme files an appeal, then it means the particular ruling is suspended. So that is some of the challenges that we see from a regulatory perspective.
How many penalties have you imposed for breaches of Section 59?
Chair, I think my colleague
it's
from
not
the...
with you, okay, it's with Mr. Cele.
It's with Mr. Cele.
All right. Anyway, carry on. You were telling us about the SCA judgment.
Yes, Chair. We chose this particular judgment because, it's the SCA judgment. We don't have the latitude of other matters that sit within the CC or other jurisdiction. But what this particular judgment has said that the liability of schemes does not exist in substitution for the liability of a member, but as an adjunct to it. This was in reference to Section 26(1). Of the Medical Scheme Act, which says upon the contractual relationship of the scheme and the member, the scheme then assumes liability in favor of the member. So the SCA saw the liability of the scheme towards the service provider not existing without the contractual relationship with the particular member. So absent the member, then the liability of the scheme towards the service provider will fall away. So that's how the SCA saw this relationship. And they went further to say Section 51 of our Act recognizes that a healthcare service provider will ordinarily render its account directly to schemes, which is the normal practice. And the court said, this is for this reason why it obliges service providers, in addition, to furnish account and statement directly to members. And the court went on to say they also recognize that schemes may pay service provider directly. And this is important because when you look at Section 59(2), it says the member or. So it envisages a situation where the scheme can pay either the member or the scheme. So at present, Chair, the point of departure in terms of looking as to 59, these are the words which was used by Judge Wallis, was to say this can only be because the claim of service or of the service provider must arise in circumstances where the service provider was entitled to advance that claim against the medical scheme, and the scheme was obliged to pay for it. So the current position within CMS in terms of interpreting 59 is to ask ourselves, did this particular claim arise where the service provider was entitled to advance that claim against the scheme, and the scheme was obliged to pay? This is fundamental, Chair, because it says to us as the office, if the claim ought not to be paid by the scheme, there can be no claim that the service provider could force the medical scheme to pay. So by understanding how this particular provision says to us is to say, if the claim that is being brought by the service provider, it arises in a circumstances where the service provider was legitimate to advance that particular claim, and that claim was correct to the medical scheme, then the medical scheme is obliged to pay. However, the fundamental question, Chair, which comes to mind is the court did not pronounce on the issue relating to 59(2) to distinguish between whether or not a member or the service provider. There have been conflicting interpretation on this particular judgment. Some other people, when they read the judgment, they felt it went on to attach the proposition that a scheme has an obligation to pay directly. But we as the office, we saw this to say if the service provider lodges a legitimate claim, which in any event, that particular liability ought to have been attracted in the event of a member, then the scheme is obliged to pay. But the court did not go as far as to say to us or to give us an insight that indeed the word or under 59 meant that they can either pay the service provider or the member. The only thing that we know is when that particular claim is legitimate and the service provider was entitled to advance it, the scheme is obliged to pay. But
What is your own interpretation as the regulator?
as the regulator, Chair, our interpretation is the terminology used under 59 to say "or," it suggests to mean the
You mean
scheme.
59 subsection 2?
59 subsection 2, thank you. So, or in our interpretation meant the scheme can pay either the member or the service provider, but there is no definitive obligation in terms of 59.2 to say the scheme is obliged to pay a service provider. It only envisages a dispensation that it can either be this or this, unfortunately. And even if you go under the regulations under 5 and 6, there's not even that peremptory term which requires a scheme to pay direct.
But the scheme would be liable to pay the service provider where the service provider has supplied a service to a member of that scheme. Isn't that so?
That would be correct. Because in terms of this particular charge, it means that particular claim was legitimate, arose even in circumstances where the service provider was entitled to advance that particular claim, and the scheme was obliged, meaning the claim is valid. In that particular case, then the scheme will be obliged to pay. The question now begs, and unfortunately, you know, even if you look at this particular judgment, one never gets to understand whether does it mean direct. We can only go as far as say the scheme will then be obliged to pay in terms of the SCA judgment. Whether or not direct or not, it may be an issue for interpretation and argument, or albeit if we had the sentiments of the Constitutional Court, whom would have probably come out clearly to tell us whether direct or not in terms of the or as used under 59.2.
Mr. Letzel, I'm not sure how this impacts our interpretation of 59.3. I mean, I understand there's some there are differing interpretations of this Java judgment, but I'm not sure how it affects 59.3 or what the submission is that you're making in relation to 59.3.
What I'm also not sure about is exactly how have you interpreted the judgment for 59.2 purposes. I mean, I understand that any judgment is open to several interpretations, but you are the regulator, you must bring certainty to the industry. What do you think it means?
No, thank you, Chair. I think for us as the regulator, 59.2 means exactly what I've already submitted. It means when a service provider advances a claim to the scheme in circumstances where the service provider had the legitimate right to do so, and that particular claim was valid, it means the scheme had the obligation to pay it, albeit direct or not. At that particular point, the scheme.
What do you mean, albeit direct or not? Maybe that's where the confusion is. Obligation. If the service provider submits a claim to the scheme for services provided to a member of that scheme, why should the scheme not pay the service provider?
I'm using
Is that direct payment? Is that what you understand to be direct? What would indirect payment be to the service provider?
Indirect would mean the scheme will elect to pay the member. So what I'm saying is when the service provider advances the account to the scheme, under 59.2, it's clear, and the wording was used for the purposes that the scheme has an election to pay the member or the service provider. If the dispensation did not envisage an election, it would have been a member. But it went on to say, or a service provider. So the intention foresaw that the member could get the services and they could pay for themselves, meaning the scheme has to reimburse. Or the member could attend to the service provider and the scheme would pay direct to the service provider. Hence, I'm using the word direct. Our interpretation, as I've alluded earlier, is that when the service provider advances a claim in circumstances where that particular claim was valid and there was an obligation to pay, the medical scheme has an obligation to pay. The problem and the difficulty that we sit with is we don't have the benefit of another judgment which has come and informed us as to the wording under 52, which says, or does it mean you can do it direct or you choose? But by the wording, and by the wording of the word or, for us it will mean it's some form of an election.
Okay, so it's not clear how that relates to what the scheme may or may not do under 59 subsection 3, right? There are two distinct scenarios there. There's section 59.2, which says it may pay the supplier or the member. Why would that, let's just clarify that. We know that section 26 of the Medical Scheme Act obliges the scheme to assume liability for benefits that have been granted to the member, for want of a better word. So if a supplier provides the service, the scheme is obliged to pay the supplier upon presentation of an account. Isn't that so? Mm. It may be that a provider says to its own patients that we don't want to submit claims to the schemes. We want you to pay upfront. You may then claim from your scheme. So 59.2, the or, permits the member then to submit the account to the scheme for payment. Isn't that the extent of 59.2? Why is there such a controversy over direct or indirect payment? That's my first question. And the second question is, what does it matter anyway, insofar as section 59 subsection 3 goes, for our purposes?
I think.
You don't have to answer all of these questions yourself. There are many people at the CMS. I think we're just teasing out various ways of looking at the problem. So don't make it your problem. If you are finished with what you have to say, just let us know. Move on to other topics. So,
no.
But the choice is yours.
No, thank you.
As long as someone in your team answers.
No, like I've already said, Chair, I've made all these judgments available for you, just for your consumption. So that will be the end of my presentation. Thank you.
Thank you, Mr. Lutswalo. Mr. Cele.
Good morning, sir. Thank you. There have been several questions that have been asked. I think probably it might be best to address them at the end, once I've set out what we have seen and what we understand to be the true scenario out there. Firstly, in our processes, we have had to investigate the allegations of non-compliance or contravention of Section 59. And in our approach, we have looked at this from the definition of the business of medical scheme. If you look at Section 1, it speaks to the undertaking of a medical scheme, liability associated with rendering a relevant health service. And I'm skipping other words, by any supplier or group of suppliers of a relevant health service, or by any person, in association with or in terms of an agreement with a medical scheme. It will become relevant later to see the obligations and the relationship between a supplier and a medical scheme, because there is a question whether is there a relationship. And the submission is that there is a relationship that is established in terms of the Act and in terms of the rules. If you go to section 26(1)(b), it speaks to liability for and guarantee the benefits. Basically, the full reading of the section says, any medical schemes registered under the Medical Schemes Act shall assume liability and guarantee the benefits offered to its members. And the word that has to be probably noted and that permeates the entire Act is benefit. You see it in section 1 in the business of a medical scheme. You see it here in section 26(1)(b). I will take you to 26(4)(a). It speaks on limitation on use of medical scheme funds. It says no amount shall be debited to the account contemplated in section subsection 1C other than payment by a medical scheme of any benefit payable under the rules of a medical scheme. Again, it speaks to the business of the medical scheme. It says what may or may not be used by funds collected from members. If you then go to section 59(1), the understanding is that 59(1) speaks to an obligation to render a statement. That is the extent of the importance of section 59(1). Ordinarily, in terms of the law, you only are obliged to issue a statement to one party. And here the section is obliging provision of a statement to more than one party by a supplier. 59(2), the obligation to pay a benefit. Firstly, it requires an assessment of a claim and payment within 30 days. It also allows for calling for correction of the submission within 60 days. Failure to question within 30 days shifts the onus of proof to a medical scheme in the event of a dispute. And again, the...
Getting that now from Regulation 6.
Yes. If you read the wording of section 59(2), it again speaks to a payment of a benefit. It does not speak to a payment of a claim. And I think that is an important distinction, because the payment obligation is of a benefit, not of a statement or a claim as such. Reading that together with Regulation 6, the Regulation 6(1) is a prohibition on the scheme to limit any payment as a result of a late submission. Beyond that, the regulation is of no use unless it's a late claim. Basically, you can't limit payment or exclude payment unless it's later than 4 months. It doesn't speak to whether it's erroneous or it's fraudulent or as such.
Sorry, Mr. Ngcukaitobi, I really don't want to interrupt your flow. I just quickly, you are confirming then that the understanding of the council is that Regulation 6 gives effect to Section 59(3). 2 and 3. Is that right? It's an implementation of section
Correct, yes.
59(2)
Yes.
and 3.
Yes. The provisions of Regulation 59(3) are basically provisions for set off. And that is where we then find problems, because that's where you start seeing investigations and recoveries that have given rise to this investigation. In terms of Section 59(3), the medical schemes may deduct money from benefits. So if a medical scheme is enforcing or is acting under the provisions of Section 59, it can only recover from benefits that are payable, which is distinct from recoveries in certain instances where you go to the provider and say, pay back. That is distinct. The provisions of Section 66, and I'm jumping in between sections, so if I'm losing you, please advise so that I don't become a scatterbrain too much. They seek to address false claims, false misrepresentation, and omissions in regard to payment of benefits. Basically, in terms of Section 66, that is rendered a criminal offense. The provisions of Section 66 are applicable to any person, so it basically covers members and providers as such. Now, before getting into the issues of what we have seen on Section 59, I want to take you to the concerns that have been raised by healthcare professionals with CMS and have been investigated by CMS. One, there have been allegations that medical schemes or through the administrators, they use entrapment to investigate possible fraud. That there is an extrapolation of the extent and value of alleged fraud, waste and abuse, stroke corruption that is used to determine recoverable amounts. In other words, there isn't an exercise where a scheme establishes how much exactly do you owe. They will come up with a guesstimation, for want of a better word. Thirdly, there is an allegation of coercion or extortion of service providers to sign acknowledgement of debt agreements. And lastly, there is blacklisting or blocking of service providers from providing any health service to members of medical schemes. We have conducted broad investigations that have covered more than 50% of the industry by size of medical schemes and administrators that we've looked at. The broad findings that we have noted is that the practices alleged exist and they are being practiced. They are in contravention and are inconsistent with the provisions of Section 59 and regulations. What has been noted is that it raises issues of self-help, due process or lack thereof, rule of law, adjudication or resolution of legal disputes as envisaged under Section 34 of the Constitution. Medical schemes, in justification for their methods used to fight this alleged fraud, waste and abuse, which I may add quickly that we agree it exists. It's a real scourge in the industry. Cite high volumes of claims and the litigation delays that would attach to implementation of recovery processes envisaged under Section 59 if these provisions require use of summons to recover, among other means.
Mr. Tlele, can I ask you, I understand your evidence to be that you've conducted inspections in relation to over 50% of the market, and you found abuse, well, let's not use the term abuse, you found breaches of Section 59 and Regulation 6, Section 59.3 in particular. Presumably as a result of those inspections, you've requested remedial action. Could you share with us what remedial action you've requested?
Can I just address it towards the end?
Thank you.
As I was saying, the reality is that on the other hand, the findings have confirmed that service providers do submit fraudulent claims against medical schemes, and some of these providers are repeat offenders and to the same medical schemes, which is an area of concern, which I will try and address later. Now, there is also other issues that in the investigations we came across. There are certain rules that have been registered that enable medical schemes to block or attempt to recover funds in a manner that is inconsistent with Section 59. The registrar has and the council have only two options in our minds. One is to persuade the medical scheme to amend the rules, and it's not always easy to obtain such relief. And in some way, I will try and address this, because as part of the remedial attempts, during the investigations, we have attempted to get a medical scheme to amend these rules, and they have held fast to the view that the rule should persist. Alternatively, the council can approach court in terms of Section 51, subsection 1, and subsection 5, paragraph C, to amend the rules of a medical scheme through a court, because the unfortunate situation is that once the rule is registered, the registrar is unable to reverse such a rule absent a court process. There was a question asked about the rules and whether they are binding. If you look at Section 32 of the Medical Schemes Act, it reads that the rules of the medical scheme shall be binding on any person, and the on any person is applicable in this instance because it is in addition to members of a medical scheme, to officers of a medical scheme. So it's broader and wider than just members strictly.
May I just interject for a second there? Just so I understand, why the remedial measure to amend the rules, either via persuasion or court application, where there's a breach of the section, where conduct is in breach of the Act? Is it not appropriate to enforce compliance in another way? Why the rules, which are seem peripheral, actually? There seems to be evidence of, potentially in some instances, evidence of the breach.
If you can just take me through that again, I think I'm missing your question.
My apologies. No, I'm trying to understand. So I understand you're answering the question what remedial steps you've taken in relation to enforcing your findings and inspections. And I understand you found that there was a breach of Section 59. The obvious example, and I don't know the facts of your case, but the obvious example being having to sign an acknowledgement of debt doesn't comply with Section 59.3 because that only allows deductions. So there's a clear breach of the Act that you found, as I understand it. So is there not a mechanism to require the schemes to comply with the Act, which doesn't involve a change to their rules?
Why don't you instruct the scheme to stop breaching the Act?
Why not charge them with an offence under Section 66?
It becomes a debate, basically, because
Why is it a debate? What is the problem that you are facing that makes it impossible to tell the scheme that it must stop breaching the Act?
taking you to Section 66, the directives that the registrar may issue are only permissible in terms of our Act to obtain information, and basically if there is no provision of information, to impose penalties in terms of Section 66(3). So absent that, the Medical Schemes Act does not provide at all for imposition of penalties for non-compliance with the Medical Schemes Act. In other words, the only available options is you refer the matter to the NPA in terms of Section 16, read together with Section 66. Alternatively, you follow the provisions of Section 26, you suspend or you cancel registration of a medical scheme, which takes it to the extremities of the provisions of the Act. There isn't a workable and enabling provision that allows a scheme to continue operating and allows the registrar to compel compliance in this instance where there is resistance.
Sorry, that's the point we're trying to understand. Why don't you write a letter to Scheme X and say that your acknowledgements of debts are illegal, stop them?
In respect to the investigations that I've just referred to, there is a role registered. We said this role is inconsistent with the Medical Schemes Act and the regulations thereto. The response is the registrar has registered a role, and that role is in effect, and that's it. We'll live by that role. So the next step is then to proceed by way of Section 51 to set that role aside before we can do anything really.
No, forget about the rule. The rule, as Ms. Williams points out, might be a manifestation of a breach. What is an issue is that the conduct of the scheme is breaching the Act. You are responsible to enforce the Act. Why don't you tell the scheme to stop breaching the Act by stopping the AODs?
The nub of it is every time we tell them they should stop what they are doing and there is a rule in place, their response is we are empowered in terms of our rules to conduct and manage the affairs of the medical schemes as they are. Maybe there is a limitation on our side in how we have sought to direct medical schemes to stop using AODs as such. However, as I was saying earlier, why does it become a debate? Medical schemes have argued that where there is consensus between a supplier and a medical scheme, that there is a liability. Acknowledgement of debts per se are not unlawful or in contravention of any Medical Schemes Act provisions as such. The issue arises where there is a dispute or there is an allegation of coercion made against the medical scheme. And that issue only arises when someone comes up to us and says, I was coerced, actually, there wasn't mutual agreement. So in that regard, one of the recommendations that have come up as a result of the investigation is if medical schemes must establish a liability, someone else independent of medical schemes should be able to determine that there is a liability owed and basically serve as an arbiter between the two parties and be an objective determinant of whether there is a ground for an acknowledgement of debt or not. Absent that, we are unable to say out and out acknowledgement of debts are unlawful per se. And more so when they're saying we are not necessarily relying on Section 59 as such, but if we believe that you owe us and we seek to recover such, we should be entitled to do so.
Let me understand this, and maybe there's a systemic problem. Your feeling is that the Act doesn't give you enough administrative role to regulate the schemes. I mean, we're putting the example of an AOD that is regularly used, but your feeling is that it may be illegal. As a hypothetical scenario, you say you've got no power under the Act to instruct the schemes to comply with the Act.
Maybe the response should be more nuanced. The AOD per se is not our view that it's illegal as such.
Yes.
However, how it is utilized and how it manifests has proven to be illegal in certain instances or unlawful in certain instances, to the extent that it is used under coercive circumstances. But other than that, on its own, we do not hold the view that an acknowledgement of debt is an impermissible instrument.
Those instances of an abuse of an otherwise lawful instruments, why are you not stopping them? I'm trying to understand what exactly is the limitation that you are perceiving.
The limitation is that in as much as we may instruct a medical scheme not to enter into AODs under coercive environment, we are unable to observe and regulate that because they are entered without our absence, without our observation, and without our supervision. If there is an environment that can be created that can enable that kind of supervision, then yes, an instruction to say stop entering into coercive AODs can be ultimately enforced. But as is, it comes to us as an after the fact when there is a dispute. I'm hoping I'm coming through on this.
No, that's fine. I'm not making a judgment. And then in relation to the rules that are inconsistent with Section 59, where you have established for yourselves that they're inconsistent, why are you not stopping that?
Why have we not approached court to set those rules aside? Is that the question?
There are many options available from a remedial point of view, but all I'm asking is why do those rules still exist, even though you've taken the view that they are illegal?
Some of those rules we have sought to have them deregistered or scrapped. The medical schemes involved have taken us on appeal on those, and we have failed basically to set them aside. The next option, and this is on Senior Counsel's opinion obtained recently, I think it was in April this year, is that we should proceed by way of Section 51(1) of the Medical Schemes Act, and that is the next step. to set aside the rules that have been already registered. The alternative is, in terms of Section 31, we can and are rejecting such rules when they are being registered for the first time.
I mean, this last part of what you said seems that it won't have much of an impact on any of this, because I don't imagine there are many medical schemes that are being registered now, are there? Are there many new applicants for registration?
No, however, annually medical schemes tend to submit rules, and they can amend rules at any point in time.
But you're saying that that's not really effective, because if it's an existing medical scheme, you can't say, you feel that you cannot impose a threat of deregistration because it would be going too far. Is that right?
Yes, the challenge that we have is the multiplicity of medical schemes with such rules already registered may make it not easy to deal with it.
Okay, I don't want to labor that. I think you've answered my colleagues on the rules, and whether or not we're not expressing a view at this point about whether that's a correct interpretation of how to deal with rules that are in contravention of the Act. But let's take another example. You have submitted to us that Regulation 6 gives effect, is intended to give effect and to implement Section 59(3). Am I right? So Regulation 6 places the onus on the medical scheme once a certain time period is up to prove that liability is one, that it exists, that it's a clear liability, sorry, not a liability, it's a clear erroneous, whatever the issue is, whether it's an erroneous payment or unacceptable payment, that the basis for which they have to establish that, the grounds for which it's unacceptable, they would have to also properly quantify what the extent of the unacceptable payments are, right? The onus would be on the scheme. Is that so? Now, we have heard complaints that there is no onus that is discharged. That onus is not discharged by the medical scheme. That action is taken against a supplier without having met that onus of proof. So that would be a contravention of the Act and the regulations, isn't that so? Yes.
Yes, that is correct.
This is not, I'm not talking about rules, I'm just talking about that conduct. What do you do then in the face of that contravention by medical schemes?
This is where we get presented with a dispute between a provider and a medical scheme alleging that I'm being compelled to pay an amount that is not proved. And that is a contravention, with or without rules. It's as a matter of law, an obligation an obligation or a liability to someone must be established.
But my question is, how do you then enforce the Act and the regulations where the medical schemes have not assumed that burden of proof?
Usually it manifests itself as an acknowledgement of debt between a medical scheme and a provider, which creates a different scenario, because is CMS in a position to adjudicate then an acknowledgement of debt and the question of whether it's legal or not?
Sure. I've heard on the acknowledgement. So let's say there's no acknowledgement of debt, because there are cases where the supplier has refused to sign an acknowledgement of debt. So what do you do then? Sorry, and this is related to because what we've heard is that the schemes you've spoken about direct and indirect payment, but where there's a blocking of a particular provider, it means that the members cannot use the services of that provider. So it would affect the members too. So what then does the council do to enforce the act and the regulations in those circumstances where there hasn't been an AOD that complicates matters?
In those instances, we have had instances where a provider has refused to pay to sign an acknowledgement of debt. The medical scheme has virtually blocked such a provider and informed members that if you access health services from provider X, we will not pay you. And the members have accessed services from such a provider and attempted to claim and have been refused reimbursement because they would have paid upfront to the medical service provider and will then take an invoice, go to a medical scheme and say, I saw Dr. X and he treated me or she treated me for this condition, here is my claim, and they've refused. In those instances, we have intervened and the medical schemes have ultimately paid. However, because they are case by case in nature and they do not come to us until a member complains, it becomes a painstaking exercise to enforce. And medical schemes, unless in good faith they start complying without us enforcing or supervising such blocking, it becomes a tenuous exercise how we can ensure that every time such a claim is presented to a medical scheme, it's paid. We have alerted and we have warned medical schemes that this is a contravention. They do pay because they appreciate that it is a contravention. However, the problem is that systematically, if you get every day a claimant going to a service provider, it must always come to us and we must always, on a repetitive basis, issue directives to medical schemes. And this doesn't only manifest itself in that format. We also see from same medical schemes a sort of a churning of matters. They will do it to several other parties, but it comes to us as high volumes because you are seeing a medical scheme A with 10 parties that are affected coming on a monthly basis. It's patient 1, patient 2 on a particular day, and it just goes on. So there is a systematic problem that we are faced with, and unless we have an intervention that can address this at a system level, we will have to deploy high resources just to monitor that there is compliance at that level.
But you said that the schemes acknowledge that it's a contravention of the Act and the regulations.
Yes, they do because they ultimately also do pay.
Do the schemes not take the view that in fact there isn't an onus of proof on them to establish that there is an unacceptable payment, that the payment that they made was unacceptable?
In the cases that we have investigated, when the schemes have paid, after having blocked the provider, they haven't taken that issue. All they have said is, we have warned you not to use such a provider. In future, we will not be able to pay if you access services from that person. However, when the claim goes in again, they still pay because they understand, in as much as they can hold that position, it's more a persuasive position really than a regulatory provision or a compliant provision. But that is the problem that we have, that schemes are taking that leeway.
What authority do the schemes have to tell members not to use particular service providers?
In certain instances, in terms of the rules, they do provide for blocking of providers.
So the
in instances,
the rules of the scheme.
Yes, in terms of the rules of a scheme. In certain instances where there isn't such, they block without relying on anything, and basically it's non-compliant with their own rules. It's non-compliant also with Medical Schemes Act.
The first function of the council is to protect the interests of the members of schemes, to protect the beneficiaries. That's the first function, responsibility of the council. In your investigations, have you found, what are your findings in relation to the impact on members of this conduct?
The impact is, one, access to health is impacted on, because instead of going to the closest service provider, members are forced to either access it away from where they ordinarily would access healthcare from. Secondly, in disputes between service providers and medical schemes, there is apparent little regard for the beneficiaries and the question on benefits that are payable. Rather, the focus is on conduct of a service provider, even in cases where a patient has sought and obtained healthcare benefits merely because there is a dispute. Such a beneficiary is then affected, and this is more than one beneficiary. It could be several beneficiaries that fall under a similar, or one administrator that sees several, that has got a broad spectrum of medical schemes, because you then have that provider being flagged across all medical schemes. So this impact moves beyond just one medical scheme vis-a-vis one provider, but it's wider and has a halo effect on beneficiaries beyond medical schemes, beyond one medical scheme that may have an issue with such a provider.
Thank you. You can wrap up if you there are any aspects that still need to be dealt with, and then Dr. Kabane can conclude.
One other thing that probably is important for our purposes, because in as much as we make findings that there is apparent fraud by providers as well, and by members in certain instances, in terms of Section 16 and in terms of Section 66, there's limitations on what CMS may do about that. In regard to providers, in terms of Section 16 and 66, the Medical Schemes Act, the Medical Schemes Council and the registrar may only report such providers to organizations that have got jurisdiction over such people, and it's referred to as improper, disgraceful, or improper or disgraceful conduct, which speaks to conduct that may not constitute fraud, but it's unacceptable and probably would fall within the ambit of what we call waste and abuse.
Thank you. So, Dr. Kabane, I think you mentioned at the beginning that you would want to come back after all of your presenters.
Yes, thank you, Chairperson, and I'm not going to read everything. I just wanted to make a few points around fraud, waste, and abuse, that it is a major problem in the country. There's an estimation that up to 15% of all claims are associated with fraud, waste, and abuse. And our own calculations based on claims that have been paid out is that this amount may sit between 22 and 25 billion per annum. And basically, these are resources that are supposed to be directed at providing quality services to members that are now being diverted to other parties here. We understand that, members of schemes or service providers, either on their own or in collusion, are actually responsible for these fraudulent activities. But we are also concerned about the behavior of the schemes and the administrators in the manner in which they conduct themselves, where there's a suspected a fraudulent transaction, because we believe that they exceed their mandate. And I think it is very clear to us that where there's a dispute between the scheme and the service providers, the ultimate victim here is the member of the schemes, either through lack of access to the service or basically through exorbitant co-payments that sometimes lead to the impoverization of members where there are catastrophic expenditures. So I just wanted to make the point that CMS has long foreseen this problem. And as early as February this year, we convened a summit where we brought all the key stakeholders in to try and get to the bottom of how we can prevent and reduce fraud, waste, and abuse here. And the result of that was a summit. And the products of that summit was the key definitions that have been agreed upon that are related to fraud, waste, and abuse, as well as a charter which we have attached as part of our submission. And this charter talks to the key principles that the signatories are committing themselves to. And these are largely anti-fraud, waste, and abuse. And basically the next step would be to develop a clear codes of good practices for all the key stakeholders around fraud, waste, and abuse here. And we are hoping that through this exercise, when we see recommendations, they will start to talk to that. Because we believe that in the absence of clear rules on how the different parties should conduct themselves, we get a lot of these different interpretations and people playing outside what is acceptable, what is legal, and what is ethical. So we're hoping that, through these recommendations, we'll be able to construct these codes of good practice. By way of conclusion, I just want to say that I hope through our presentation, we've been able to demonstrate that whilst we've currently used what sits in the Act and regulations, there are clear discrepancies in terms of how we should actually be operating in an environment where, there's empowerment to the regulator in terms of clear acts and regulations. And we believe that we've also demonstrated that Section 59, together with this Regulation 5 and 6, is problematic in the way that it sits right now, and clearly something needs to be done to provide more clarity. And I think some of the inputs have made reference to some of the key areas that I just wanted to emphasize. Firstly, when there's a suspicion of a fraudulent claim, what kind of processes allow schemes, administrators, and service providers, including the members here, to get an engagement so that there's a proper confirmation of that diagnosis, and also how to proceed once that fraud is detected. Because whilst the rules and the laws and the regulation clearly say if there's fraud, it needs to be reported to the responsible authorities, clearly within the industry, there's collusion between fraudulent service providers and the schemes and administrators where they sign these acknowledgements of debt, when in fact those cases should have been referred to, the law enforcement agents. We also are hoping that we need to clarify the area that are problematic around at what stage should an audit be conducted, how should it be done, and what rules should be followed. We also think it's important to address this issue of guaranteed exclusive payment by service providers, because I think it's common cause. I mean, I'm not a legal practitioner, but I think if you are a general practitioner, and you provide a service to a patient in good faith, and you provide a legitimate claim to a service provider, you expect payment, that it should be made direct. So you need to unpack and say, under what circumstances should this be done here? Are there certain additional things that service providers need to do so that this is guaranteed and it's exclusive? I also think the issue of clawbacks needs to be closely examined, because they just seem to be unlawful and are not governed by any, rule or legislation. And I think we need to put that to an end. But CMS chairperson is looking forward to the recommendations, and we don't think we are angels in these discussions, because clearly there are certain things that we should have done, but we'll await the recommendations and implement them. Thank you.
Thank you, Dr. Kabane. It remains of me then to thank you, Dr. Kabane, and your team for your input this morning. It's certainly been very enriching and enlightening. Of course, it has not been, we don't hold back, but that's the nature of the animal. Thank you. The session is adjourned until, I think, half past one.